Afternoon, everyone. I'm Joan Cradden from Brodie's Employment Team, and I'm joined by Lynn Marr. And we are talking today about menopause at work. Just a quick introduction. We hope you find this session useful, obviously. It's quite a big audience. We are going to take some questions if we can. If we can't get to everyone, we will ask you to complete a survey at the end, and we'll get your details and we'll be able to answer the questions directly where we can. We're going to record this session and we're going to circulate the recording after the event anyway. If you do need a question or you have a burning question, please use the Q&A function to ask that question during the presentation. We will try and, as I said, get to the questions that we can manage to get to, depending on the time. We are going to do the usual. This is a whistle-stop tour of a subject which is close to many people's hearts at the moment and is obviously very much in the media. In fact, it's pretty hard to miss at the moment. Much of that is down to the work of a few media personalities and social media stars. I thought I should begin by telling you, just out of interest, I was at a meeting yesterday of a group of European employment lawyers, around about 20 countries represented. And it was very interesting to learn that this subject has not really hit the agenda for many of them yet, even in places like Sweden and Denmark. We often think of those as being very progressive jurisdictions, but they haven't tackled this yet, which is really interesting. It is a new subject, and it's a new subject in the law, and the law doesn't quite know what to do with it yet. And so today we're going to focus really quite specifically on what the law is doing with the subject at the moment, and then to look at what that means for policy development. I am going to talk a little bit about where it might go, but there'll be a degree of speculation in that. As I said, a lot of the social media coverage is pretty negative. You have to dig quite hard at the moment to find something that's really positive. I picked that one from Oprah Winfrey, which is now on your screen. I think that it's a nice way of thinking about what the menopause means to many. But as I said, this is not going to be a seminar about the medical status of the menopause. Next slide, please. There's a wealth of information. I am not going to give you the list of menopause effects. What we do know is that there are more effects than we thought there were maybe 10 years ago. And we have, of course, Davina McCall and Dr. Louise Newsome to thank for all of the information that is now available. But as I said, this is not a seminar about that medical status per se, and we're not going to list the subjects. We are going to talk a bit about who's affected. So this is, I suppose, information for anybody who's not familiar with the subject. The menopause has no fixed start date. The perimenopause period, when the hormones estrogen and progesterone start to decline, can start as early as your 30s, but most often between the ages of 40 and 45. The average age for menopause is between 45 and 55. Early menopause affects around about 1% of women under 40 and 0.1% under 30. Some, obviously, people become menopausal as a result of medical treatment, including treatment for cancer. And there, of course, are also specific issues relating to hormone treatment and hormone levels for people who are trans and non-binary. So there's a list of people to take into account when you're talking about the subject. So I'm going to hand over to Lynn shortly, who will talk about the law. But just very quickly, just on the status, on the number of claims we've got, claims mentioning the menopause are increasing. We've got about 44 reported cases mentioning the menopause since 2017. There's a new set of statistics which suggest that in 2021 there were about 23 cases mentioning the menopause. They're pled in a variety of different ways. The most predominant pleading now is disability discrimination, and the success rate is still relatively low. As I've almost got to it, the legal protection might in theory be derived from anti-discrimination legislation on age and sex and disability. The health and safety framework contains protection as well. And legal commentators' concern about this, including a number of specialist groups for employment law, is that the current legislative framework isn't fit for purpose. And I think what Lynn's going to begin to talk about will demonstrate to you why we're struggling a little bit to deal with the subject in the law.
Okay, thanks, Joan. Yeah, so the first one, age discrimination. So Joan mentioned that this might be one route towards bringing a menopause claim under the existing framework, and that's because obviously of the association of menopause with that age range of between 45 to 55. But these claims haven't really been without difficulties. So if you think, for example, that we've talked about the menopausal age being between 45 to 55, there's no agreed menopausal age range in the case law. So people who start to experience perimenopause or menopause could start to experience that at a much younger age. So direct discrimination claims, for example, can be problematic. If you take, for example, I'm not thinking of anyone in particular, i.e. myself, a 48-year-old woman who might try and argue that I've been refused a job because of my menopausal status in favour of a 30-year-old, you might find that an employment tribunal says, well, the reason could indeed have been the fact that you weren't sufficiently competent, but it wasn't because of age in any event, it relates to your hormonal status. And a 30-year-old woman could have a similar hormonal status. So it could relate to that and not directly to age itself. And of course, hormonal status is not in itself a protected characteristic. Indirect discrimination claims might have a chance at least of getting off the ground if a claimant is able to show that there is a provision or a criterion or practice that an employer is applying. They might get the claim off the ground, but the difficulties then with those kinds of claims is that claimants have to also be able to show that the group that they are in, i.e. that maybe that 45 to 55 age group, is actually disadvantaged in some way. And that was the issue that Mrs. Sloan came across. So on the slide we refer to the Sloan against Dumfries and Galloway Health Board case. She was able to show that there was a relevant PCP, which was the air quality and the low temperature. So that was good, she got her claim off the ground. But unfortunately, she just wasn't able to lead any evidence to show that those temperatures did adversely impact women in the age group she was relying on, which was the 50 to 65 age group actually in her case. And actually men and other women who were outside those age groups were potentially also affected. So she couldn't get over that hurdle and the claim wasn't successful. Harassment and victimisation claims we've certainly seen probably a little bit more success. So we've got there's another couple of cases which we've had, one called A against Bon Marché and another one called Best against Embark on Raw Limited. And in the Bon Marché case, the claimant there, I think, was referred to as a dinosaur, and also had her inability apparently to staple two bits of paper together as being related to her menopause. And in the other case, Best against the Embark on Raw case, the claimant there was described as being irrational, obsessive, paranoid, and actually had it suggested to her that she might well be menopausal. So both of those claims actually did succeed on the basis that they were harassed. So they were successful, but those sorts of claims actually can be quite tricky because they brought their claims based on both age and sex. And as we'll come on to see, Section 14 of the Equality Act, which allows for these dual discrimination claims, has never been implemented by the government, and there doesn't appear to be any plans to be. So those cases, a lot of these cases do turn on their facts, and those ones probably did. So what about sex discrimination? Has that fared any better? Well, I just talked about the Bon Marché case and the Best against Embark on Raw. Both of those were harassment and victimisation claims that did actually refer to sex discrimination. But direct discrimination claims can also be really difficult here as well. And that's really because menopause is something which is unique to women. And I am deliberately referring to women here because there is case law which says that under the Equality Act, the definition of woman is a biological female and man is a biological male. And you can see we run into this immediate difficulty that it is only biological women, whether that's a woman, a trans person, or a non-binary female, that is experiencing the menopause. Male biological men do not experience menopause, and it's a fundamental principle, obviously, of equality law in most cases, that you need a comparator. You need to be able to show that you're being treated less favourably than somebody whose material circumstances are the same, except for the protected characteristic. And so we have to do these kind of mental gymnastics in these kinds of cases to find the right comparator. And that was what Mrs. Merchant had to do in her case against BT. So she was somebody who was not performing particularly well. She was suffering menopausal symptoms, which impacted on her concentration. And when she was really getting to the final stages of that performance management process, she produced a letter from her GP, which perhaps attributed some of those issues to her concentration and to the menopause. Her male line manager felt that there was no need to refer to occupational health. as was required by the BT policy in this kind of process, because both his wife and his HR manager had suffered the menopause, and therefore they could tell what impact it would have on performance, so no need to refer to OH. Her claim did succeed as a direct discrimination complaint because the policy clearly said that you should refer to occupational health if there were medical issues, and the tribunal really had no difficulty in finding that a man who suffered from some sort of ill health condition which impacted on his concentration would have been referred to OH. But you can see you've got a slightly odd mental gymnastics to get to a comparator, and some would say that it would be better if we got to a position like we did after the Webb against Air cargo case with people bringing pregnancy discrimination claims, where you just don't need a comparator at all if you're relying on menopause as a protected characteristic. And indirect discrimination claims can also be slightly difficult as well. So, if you've got a provision, criterion or practice being applied, for example, in an absence policy with absence triggers, you're applying them mutually to everyone, menopausal women might well be disadvantaged because they might have to take more time off work to deal with their symptoms. That might be a little bit tricky, again, because all women suffer menopausal symptoms in very different ways and to very, very differing degrees. So it can be very difficult to establish that those sorts of criterion can put menopausal women at a specific disadvantage. And of course, you've got this, the requirement that employers have open to them, or the option to justify provisions, criterions or practices that they put in place. And so we've seen the case of Sokolova, which was a poor lady that worked in a factory, which was obviously extremely hot, I think, by all accounts, because she was on a production line. They had to, for hygiene reasons, wear protective wear that basically buttoned right up to the neck. And she was in the early stages of menopause, got hot flushes, unbuttoned one day her protective gear and was reprimanded for that. Again, in that case, the tribunal has no difficulty in finding that it was a PCP, and it might well impact on menopausal women or women generally. But ultimately, the tribunal was prepared to accept that hygiene reasons was a legitimate aim, and that requiring people to button up their gear was a proportionate way of achieving that particular aim. So there's no concept when it comes to menopause of reasonable accommodations. So in international law, when you look at some of the treaties around that, you see references to reasonable accommodations allowing women to participate in economic life. That doesn't exist in the concept of sex discrimination, and you see commentators being critical of that. The claims that have probably been the most successful have been disability discrimination complaints. This certainly has been the most common one, and it does rely, of course, on individuals being able to establish that they meet the definition of disability under the Equality Act. So they have to be able to show that they are suffering from a physical or mental impairment, the effects of which are long-term, and they're also substantial, so they're impacting in a substantial way on their normal daily living. And that seems in some ways to be quite a good theoretical framework because, as I've said, obviously menopause affects women to varying degrees and in varying ways. So it does take account of those individual variations and will give some degree of protection to those women who are probably suffering most, I suppose, severely from the symptoms. And if they are, then obviously, if they can meet that threshold of disability, then it will trigger the protections under the Equality Act. So, for example, the obligation on the employer to make reasonable adjustments, which are tailored to the individual, and also the obligation not to treat somebody who is disabled unfavourably because of something arising in consequence of their disability. So, for example, maybe not to performance manage them or issue them with warnings, or issue them with warnings for attendance because the reason for that is, the performance or the non-attendance has risen in consequence of their disability. So those protections can kick in there. So we have indeed seen some success with those sorts of cases, but there are some difficulties as well. So there will be some women who have symptoms that are pretty bothersome and maybe just arise from time to time, or have lots of different symptoms which actually do impact quite seriously in a cumulative way. And if you don't look at it through that lens, they might not be covered by the Equality Act, but they might just need some simple adjustments or accommodations to help them in the workplace. So there's that difficulty. And the other one, which is, I suppose, pretty obvious, particularly to any women suffering from menopausal symptoms, is that lots of people have a real conceptual difficulty with trying to shoehorn themselves into these provisions or referring to themselves as being disabled, particularly when it is just for people who are suffering from menopause, is just part of the natural aging process. So those are some of the difficulties that arise with disability. Now we've got, I think on the next slide, we do have references to a number of the cases. We probably don't need to go through all of them, because I've talked about some of these, as I've talked about the Bon Marché case, and I've talked about the Merchant case. Some of the cases, the disability ones at the top there, are quite interesting. There's a few more recent ones. So we've got Rooney against the Leicester City Council, which is in fact it's the first sort of EAT decision that we've actually had. And when you read the sorts of symptoms that poor Mrs. Rooney had, they're really quite awful. So she suffered from things like sweating, palpitations, anxiety, night sweats, sleep disturbance. I'm doing Davina's list or Dr. Newsom's list now. But where that led her was that she did things like she forgot to go to meetings or events that were in her diaries. She lost personal possessions. She forgot to put the handbrake on her car. She left the iron on. She'd forget to lock the doors in her house when she left the house, all because of the impact on her concentration and the fact that she was fatigued and all the rest of it. Interestingly, the Employment Tribunal in this case didn't at first instance find that these had a substantial effect on her normal daily living. And from what I've just read, I don't know how they came to that conclusion based on what I've just read out. They did. What they did actually was they compared her, because she also looked after her elderly mother and also a disabled husband. They said that actually these symptoms were trivial in comparison to what she had to do in relation to looking after her elderly mother and her husband. So they said it wasn't actually, it was quite trivial. The EAT did not agree and found that this did have a substantial adverse impact on her daily living. So, I mean, a lot of these cases are very factual, so it's worthwhile looking out for them and reading them. You see new ones coming out all the time. I've also referred in the slide to the Linda Gallagher against Abellio ScotRail case, which I think is a case probably Joan knows a lot more about than I do. But that was really a case about causation. And in that case, I think there was a concession that she was disabled for the purposes of the Act. But in that particular case, her dismissal was not on grounds of that. It was related to something else.
Yes, that's right.
Say any more about that, Joan?
I suppose the slight irony in that case was that, in fact, what led to the dismissal, the causation factor, might, on one view, have been connected because it was about a spectacular falling out between two women who were both of menopausal age at the time, and both blamed each other for their behaviour and blamed the menopause on their behaviour. But the tribunal didn't accept any of that. They just believed that it was a personality clash.
Okay. So I suppose other problems with the legal framework that we've got, well, you'll all be aware of perception discrimination. Where does that quite fit? Because menopause isn't a protected characteristic. So there will be a lot of assumptions made about, particularly about women of a particular age or people of a particular age. And there might be an assumption or a perception that they might be suffering from menopause when they're in fact not. But how do they get perception under the Act? That's not entirely clear. There is also an obvious issue around trans, non-binary and intersex workers, because the Equality Act, as I said, defines women as a biological female and male as biological male. And although there are provisions in the Equality Act around transsexual and transgender, it's just not obvious where all this would fit, because there are issues obviously affecting those groups of people that are often overlooked. And obviously there's medical menopause as well, and how that fits into the overall framework. As Joan said, it is a tricky area, this, and I think lots of people have been grappling about how we are actually going to resolve this and ensure that we have a better framework for allowing people to be protected, people that are going through menopause to be protected. Mm-hmm. So I'm going to move on to me. Back to Joan.
So I think at the moment the debate, I would say, is raging about how we handle this. Just in July, we got the Women and Equalities Committee produced a recommendation that menopause should be a protected status in employment law. The governments have so far indicated that they don't want to do that. Interestingly enough, if we introduced it as a new protected status, it would be a departure from the EU framework for anti-discrimination law. But if we might be doing that anyway. We've got the problems that we have in terms of requiring good statistical evidence to show the disproportionate impact that might be suffered by people going through the menopause, how we go about justifying protected status in the same way that, before we got anti-discrimination law from the EU framework, there was an enormous amount of research carried out in relation to how group disadvantage works in the workplace. That needs to be done in the context of menopause. There's a problem with the definition, as Lynn has already identified. And of course, we've got that whole question about what happens if medical science fixes it, if it is something that can be fixed. Dual multiple discrimination was very popular at one point as an idea, and certainly in the context of menopause, you can see why it's very attractive as an idea, because particularly in relation to stereotyping, we're getting this kind of older woman idea and the various sort of discriminatory perception that can arise in that context. There are some legal commentators prefer some form of enhanced policy provision, which would sort of effectively build in some kind of a concept of accommodation along the lines that Lynn was talking about there in terms of the menopause, perhaps linking it to the concept of disability, but not, and taking the same approach, but staying away from the idea that it is a disability per se. So where does that leave you? You're on the front end. You're trying to work out what you're going to do about this and how you're going to go about putting policies in place. Do you need one? I would say you might be behind the game if you don't have one. I think the vast majority of HR functions now in the UK are looking very carefully at the introduction of a workplace policy. What's it for? It does three big things. It raises awareness, it provides a mechanism for support, and probably also introduces the concept of adjustments. Those would be the three pillars of a good policy. On awareness, be careful, I think, not to overdo the supply of medical information. I think for people who are menopausal, sitting in a room, watching somebody put a screen up with a list of the potential symptoms of menopause is actually quite tricky. So it is very sensitive, and I think I'll talk about the data protection elements of that in a moment. But I would, in the awareness raising, there's so much public information now available, you can simply point to that. Support. Again, I think a support framework is a very good idea. I do question whether or not it's fair to expect line managers to be equipped to have detailed conversations about it any more than you would expect a line manager to be equipped to have a detailed conversation with someone about multiple sclerosis or, some form of, other form of disability. Ideally, I think the consensus is beginning to emerge that giving affected employees a safe space to raise the issue and to discuss it in private, or perhaps to discuss it with other people who are affected, is almost certainly the right way to do it. On adjustments, again, I think I've said this a number of times now, I think you're getting the message that introducing that concept of reasonable adjustments or reasonable accommodation is going to be a good thing to build into your policy. So as policies will usually contain somebody to talk to, some form of support, health and well-being education, albeit well controlled, clear guidance on data privacy. Remember that the same issues arise here as arise in connection with anybody who would be in the disabled category, anybody with a protected characteristic. These are sensitive personal data. You must be careful with it. The workplace adjustment framework tends to focus on things like temperature control and then the mental health support. Those tend to be the two most predominant features for adjustments for menopause. So accommodations on time, flexible working, breaks, all these sorts of things that might help with some of the symptoms that are listed on there, like anxiety, confidence issues, mood, and forgetfulness. So the last thing I would say, a word to the wise, and this is a sort of a summation of some discussion that I've had with a number of people recently. On the one hand, the development of this as a subject is extraordinarily positive. Sharing information about it is extraordinarily positive. I have spoken to many women who say, if only I'd known that that's what it was, if only I'd known that it was connected to the end menopause, if only there was somebody I could talk to. There's no doubt whatsoever that is valuable. And allowing people to talk about it is an extremely good thing to do, but only if they wish, and only if they're comfortable. There are potential backward steps here, and this is what we have to be really careful and guard against. First of all, don't assume that it affects everyone in the same way, and your policy needs to say that. Don't assume that it's all negative. Like I said, there are some nice things about it. Assuming that there are no paths for treatment, or more importantly, that treatment is available to everyone, is also a really important thing to bear in mind. There is a developing concern about, well, why are you not on HRT? And that sort of question coming up, and in the context of sort of performance management, line managers going, well, my wife's on HRT, why are you not? That's an extreme example, but there is a risk that we start using the information too loosely, and that then leads to stereotyping. And we all know, EastEnders and Dot Cotton years and years and years ago, that the sort of the stereotyping that arose in that context is exactly what we're trying to guard against. So I think we've said enough. There are some questions. I think there's someone has asked about whether there's an andropause factor in here, and the question of the male menopause. That's not something I know a lot about. Lynn, you're nodding. Do you know something about that?
No, I did read something about this the other day. So I know, obviously it's a thing, you hear about it. But apparently, and clearly I'm no scientific expert, but apparently there's quite a lot of science to say that male testosterone levels do start to drop off after the age of 30, but they don't cause any particular effects, or the drop off in testosterone is not linked to any effects, which people talk about when they talk about the andropause. But yeah, it's interesting because it's a thing, and I suppose the issue with comparators would arise. It's just the reverse way, because you're not going to find a female that's in the same position. It's those words, in the same position, that cause the problem, aren't they?
Yeah. Someone's asked about what happens if you, and this is actually, it fits with the Dot Cotton scenario. For those of you who are not old enough to remember the Dot Cotton reference I've just made, but in EastEnders years and years ago, Dot Cotton was caught shoplifting, and that was ultimately put down to menopause. And years ago, that was a sort of a stereotype, was that menopausal women shoplifted. But somebody has asked a question about what happens if somebody raises in the context of a conduct issue. So that's quite interesting, because we're often asked questions about performance and menopause, but this question is about conduct. Obviously, the questioner hasn't given us the detail, but I do think that if someone suggests that, I think we're back into that scenario where getting some occupational health guidance on whether or not that link is possible might be an important thing to do, particularly if it resonates, particularly if they are suggesting that it is relevant. In fact, Lynn and I were talking about a situation. We remembered somebody, a client of ours, who was accused of lifting. It was some kind of charity sale, and she lifted a bottle of perfume and she didn't pay for it, and she was taken to task in a disciplinary context, and she was dismissed for that. And when it came to the tribunal, and this is many years ago now, she did raise the fact, she said that she was so absent-minded and it was menopause related. And of course, in those days, it would have been at least 15 years ago, Lynn, wouldn't it? But she, nobody would have entertained the idea that you would send someone off to occupational health to find out whether that was true or not. But in fact, that is something that you would now need to think about, I would say. So we're going to finish off. I don't think we've got any more. We actually have quite a lot of questions, but I think a lot of them are quite specific.
Yeah. There is a comment which is probably worth noticing about the use of language in this context, and I suppose Joan and I spoke quite a lot about language and taking care of the sort of language that's used, and making sure that inclusive language is used. And I guess the reason that we refer to biological women when we're talking about sex discrimination is we're going to defer to Lady Dorian in the Court of Session, because that is the language that is used to refer to the definition of women, and like male and female within the Equality Act. But we do appreciate and accept that there is that there is a need to be sensitive here in terms of language, because as Joan said at the beginning, menopause affects not just women, but also there are impacts on trans men, and also intersex and non-binary as well.
Yeah, indeed. And finally, just your giveaway on the screen there, you've got a reference to our workbox, which is our portal, employment law portal. There are some free pages up there that you can access directly, and when you get slides, you'll be able to see the link to those. And we've got a style policy on there, so anybody who's thinking about starting from scratch and wanting to work out what a menopause policy looks like, that will be a good one to start off with. So thank you very much for attending. The recording, as I said, will be available, and happy to chat to anybody who wants to talk about the subject offline. Thank you.